Good morning.
Morning.
Mr. Chief Justice, and may it please the court. The penalty phase closing argument in this case should make conscientious prosecutors cringe. Prosecutor Harmon attacked Ritchie for exercising his constitutional rights and then intimated that because he was a non-citizen, he did not deserve them. He violated the same mercy rule, he violated the golden rule, and eventually vitiated the jury's ability to extend mercy. Prosecutor Harmon's hunger for a win inflamed both the passions and the prejudices of this jury and infected Ritchie's entire penalty phase trial with constitutional error. Today, I'm going to focus on some of the most egregious instances of that closing argument and the mother's victim impact testimony where she made a direct plea to the jury that they impose a death verdict.
Is your argument cumulative? Is the argument that the statements in their entirety
Absolutely.
merit reversal? Okay. I wonder if before we get to that, though,
Sure.
we might, first of all, have we ever reversed on the basis of a same mercy argument alone? Have we ever found that standing alone, a same mercy comment in closing or elsewhere in trial constitutes reversible error?
I do not believe so. However, it's not standing alone. That's not how the harm analysis
I agree.
works.
I just want to make sure that I
No.
understand the component parts. Okay.
Not that I know of.
Certainly a golden rule violation we have
Yes.
held can constitute reversible error.
Yes.
What about the immigration commentary?
Not that I know of. However, it may not be a common argument. That may be why we don't have an opinion on it.
Okay. And so for your theory to prevail, we shouldn't be looking to the same mercy alone. We shouldn't be looking to anything alone. Your argument is one of cumulative prejudice.
Absolutely. I want to say something about prejudice, and it applies whether or not you're doing harmless scrutiny or whether or not you're doing fundamental scrutiny. The impact of prejudice looms so much larger in a penalty phase than it does in any other proceeding in America. And the reason for that is not just because each individual of those 12 jurors has veto power over a death verdict, but because unlike guilt phase determinations, conviction determinations that turn largely on the evaluation of objective facts, whether or not to kill someone is an inherently moral determination. And each individual of those 12 jurors brings with them to death and life deliberations unknowable ranges of human experience, unknowable ranges of reactions to the same types of evidence, and it's because of that that their collective judgment about who should live and who should die is marked by an inherent lack of predictability. I want to talk about, I think, the most egregious.
Where does that leave you? Does that leave you basically saying any error in the penalty phase is a per se error?
No, absolutely not. I can think of.
What does it mean then? I mean, because it sounds like you're trying to change the standard, the typical standard we would use for determining harmless error, right? You're saying that's got to be different.
No, I'm saying that what the jury does is different. So this idea, for instance, when you have a trial, is there enough evidence to convict is not the only question you ask yourself when you're going through harmless error analysis. But it is a big part of it. Is there sufficient evidence to convict but for the harmless or the prejudicial arguments? For example, I think something in a penalty phase closing in a capital trial that the prosecutor says it's improper about an aggravator that the jury ultimately doesn't find, that they reject. I think that would be harmless. I think that would be very hard for me to come here and argue prejudice if that happened. But that's not what we have here.
Well, what you do have, though, is the presence, for example, of an HAC aggravator.
Sorry?
What you do have, for example, is the presence of an HAC aggravator.
Absolutely.
All right. So, I mean, I guess to the Chief's question, I mean, it can't be per se error for there to be a comment that we, for example, have never found to constitute standing alone error when there is an aggravator in the record found beyond a reasonable doubt. You'd agree that again, that you're not asking us to hang everything on that. You are making solely a cumulative error argument.
Absolutely. But I do want to distinguish, I mean, some arguments were certainly worse than others. The worst, I think, of the entire penalty phase was obviously the comment on trial rights intertwined with this, he wouldn't have had access to any of these rights in Jamaica refrain. The whole point of patriotism, frankly, is that you owe more to your brethren than you owe to outsiders. Remarks on the comment on the exercise of trial rights would be egregious in any case, right? Because the state's burden to mount its case presupposes a counterburden on the jury to sit through it. But it's especially egregious to tell the jury, we gave this man, because our country is so great, we gave him all of these rights, and he wouldn't have even had them had he been tried.
But is that what's actually in the record? As I recall the record, it was the defense that put before the jury the idea that he had grown up under underprivileged circumstances in Jamaica, and the state responded on this basis. Can you give us the actual statements in the record? Because I don't recall it being what you're saying.
I'll read it. He immigrated here to this country years ago, and as he lived here, he enjoyed the benefits of this country we live in, the greatest country on the face of the earth. He enjoyed the due process rights. He enjoyed the fact that we carry the burden of proof to prove his guilt, that he's presumed innocent, that he's entitled to a jury of his peers, not just to determine whether he's guilty, but a jury of his peers to determine the appropriate sentence. Because this isn't Jamaica or some other country, this is the United States, where the defendant gets to have you determine his sentence, not some bureaucrat, not some single judge, not a star chamber, but you, his fellow citizens. He enjoyed the benefit of a neutral and unbiased judge, the benefit of very competent defense counsel. You think that would have happened in Jamaica? I don't see how that's responsive at all to a claim of underprivilege or a terrible childhood. For instance, any of his mental mitigation. For instance, if there was some evidence that Ritchie had gone through like a long and arduous and labyrinthine immigration process, the prosecutor could have easily said, what fool could have figured that out? I mean, obviously he's got some tenacity, right? But that's not what happened. And also he could have easily said, his father sounds like a terrible guy, but, he's not that little boy anymore. He's a grown man who did a terrible thing. But also that's not what he said. He went through a litany of trial rights, which this court in Evans says there's no legitimate purpose for doing. And then he intertwined that refrain with a reminder to the jury that he's not from here. And the only logical, conclusion that a jury can take from that is that I should be dubious.
Let me ask you this
Yes.
question. When did this trial take place? What was the date?
September 2019, the last...
What year?
2019.
2019?
The crime is in 14. I want to go...
The way that you're arguing this and the way you presented it is a little confusing to me. It may just be me, but on the same mercy comments, we have case law that says that those are blatantly impermissible. Is that correct?
Correct.
And there was an objection at trial, correct?
Yes.
Okay. So it's preserved error. Clearly
Yes.
error. We said it's error. It's preserved error. So that means the state has to show beyond a reasonable doubt that the error did not contribute to the outcome.
Yes.
You seem to be conceding that the state's met its burden, because you're not arguing that we should reverse based on that alone. You're saying that we should somehow accumulate with other errors that were not preserved and therefore have this different standard that's very difficult for you to meet. So I'm
Our position absolutely is that the state has the burden of proof to prove to you beyond a reasonable doubt that the same mercy comment did not impact the verdict. But this closing argument was so terrible that the same mercy argument was compounded by other error.
If the state didn't demonstrate beyond a reasonable doubt that that error alone did not contribute to the verdict, then it doesn't matter if we've ever reversed based on that before, right? It's a reversal.
That's true.
Okay. So why isn't the argument trying to convince us that the state has not shown beyond a reasonable doubt that that error did not, I mean, yeah.
Well, I believe it's impossible for them to prove that to you, because there's no way to look to a penalty phase deliberation as if it's a lab experiment that you could sort of replicate and that you would reliably get the same exact result, a 12-0, a 12-0, a 12-0, no matter how many times you did it. I think thinking of penalty phase deliberations like that is woefully misguided. And I think that's the only way the state wins, if you think of penalty phase argument like that.
Okay. Let me ask you, going to golden ruling and HAC, the classical golden ruling argument would be something to the effect of, put yourself in the shoes of the victim.
Right.
Think of how she felt as she was dying, and so on and on. That would be the classic golden ruling argument, impermissible golden.
That did happen here.
Well, I'm getting there.
Okay.
Hang on. Here, the argument was, can you imagine the dread of knowing that your life is ending and you're feeling pain all over your body, as it's bleeding internally, and so on and on? Okay, how that is not exactly putting yourself in the shoes of the victim, but pretty close to it. How is it that this argument is being combined, obviously, with HAC, heinous, atrocious, and cruel, that aggravator? How is it that that would not be permissible just to prove HAC? It wasn't introduced on its own just to prove HAC.
It's absolutely permissible for a prosecutor, while they're referencing HAC, to say, to describe the pain, to describe the victim's pain, the ripping and tearing of tissue like he did in this case. That would be very painful. Dr. Downs told you how painful, how highly innervated those areas are. But the difference is asking the jury to imagine that the murder, that the death is personal to them.
So the proper way to have said that, or the better way to have said that as a prosecutor, would have been something to the effect of, you may consider
Yes.
how the victim felt at the time, something like that,
Absolutely.
instead of just imagine.
Imagine you.
You, yeah.
Even imagine, I think, would be fine. But imagine you is not fine.
That's interesting. Why? If the argument were, imagine the suffering of this person, imagine the pain, isn't that directly inviting a personal experience? I mean, to imagine something is to call it to mind and to reflect on what it might be in my own experience. Why aren't you arguing that, isn't your rule essentially that any kind of personal contact with the experience should be a violation of the golden rule?
I don't think you can divorce these kinds of proceedings from personal imaginings or personal contact, but for instance, in a Hack case, the murder was pitiless. It is much harder for me to imagine giving mercy to a merciless killer when I imagine them murdering me versus when I imagine them murdering someone else, even if that victim is sympathetic for some reason. I think there's a huge difference there. I want to touch on victim impact before I reserve some time for rebuttal. The victim's mother in this case read from the Bible to the jury If anyone causes one of these little ones, those who believe in me, to stumble, it would be better for them to have a millstone hung around their neck and be thrown into the sea. This demand directly to the jury for the death penalty suggests that God is on the side of a death verdict, and that is a perversion of Florida law. It also touches on the least controversial aspect of the Payne decision, and I'm referring, of course, to Payne's condemnation of survivor opinion on the defendant, the crime, or the appropriate punishment. We cite a lot of cases in the brief about victim impact, and I think victim impact, unless you are combining it in your consideration of the same mercy argument, which you can, cases like Del Hall and Evans say that you can do that, and you're under harmless error analysis, there was no objection here. So I think I need to address what it takes for victim impact to rise to the level of fundamental error. And my reading of the Florida case law, I believe, makes two requirements. One, it has to violate that Payne condemnation. It has to be a direct request to the jury to impose a death sentence. And cases like Jordan and Calise say that. They say that you don't reach the foundation of a penalty phase until you do that. Secondly, you can do that. You can make that error, even if it's plain and obvious and there's no question. But unless you do it in front of the jury, it doesn't warrant a new penalty phase. And I get that from cases like Card. Are there any questions on victim impact?
Sorry, could you elaborate on this harmless error issue? Because
Sure.
I just want to make sure that we're clear as far as what you're arguing analytically that we're supposed to be asking ourselves. So, I mean, one way of looking at it is whether you have this sort of objective jury that is, you're asking whether objectively speaking in the context of this case, whether this same mercy comment that a rational jury could have decided differently because of that comment, right? I mean, is that what we're asking ourselves? Because,
Yes.
I mean, obviously, and I understand why you haven't emphasized this, but I mean, this is one of those cases where it's hard to imagine a different recommendation from a jury than what happened in this case. And so it seems hard to believe that, and I understand you're making your cumulative point, but you also were saying that, because it was objected to that we need to do harmless error on the same mercy thing, but it seems it's hard to imagine that comment in isolation materially affecting what the ultimate recommendation was.
So I'll say three things. First of all, the danger with a same mercy argument is that not only will the jury permissibly use arguments about how the murder was pitiless when they're finding hack sufficient or not, but they will also use it when they go to that ultimate last question. Will I extend unconditional mercy? They'll use it then too. That is what's impermissible about it, and that's what's so dangerous about it. And even though you can reverse, and we argue in the briefs and here today that you should, based on that alone, you don't have to do it on that alone, because you have so many more improprieties in penalty phase closing. And again, this is not guilt phase, this is penalty phase. The issue is whether he lives or dies, that compound that error and weigh it down. So you can, but you don't have to, I guess is my point here today. If you find yourself having trouble imagining, just based on that one comment, how someone would have voted life, think about the entire improprieties as a whole. And the third thing I'll say is your comment about it being hard to imagine. Frankly, some capital defendants get 11 ones and 10 twos, and you're right. It is like unfathomable how it happened. But it happens. And when you are at the point where you are in your mind saying, if we do this over, are they going to vote death again? It is highly, highly speculative for you to say for sure, because those, and they're not really anomalies, it's quite common actually, that you're not sure that would happen. It's just very speculative to say that. Too speculative for a harmless error analysis. I'd like to, if I could, reserve the rest of my time. May I?
You may.
Thank you.
Thank you, Mr. Chief Justice, and may it please the court. My name is Rick Buckwalter, and I represent the appellee in this case, the state of Florida. Today, Granville Ritchie comes before this court and asks this court to reverse a death sentence imposed and remand his case for a new penalty phase because he contends, one, there was improper comments made by the assistant state attorney during his penalty phase closing. There were improper victim impact testimony that was admitted into evidence. The redactions that were made to a video they claim were improper, that was introduced for mitigation. And four, that the court permitted rebuttal from a witness that Mr. Ritchie argued, I guess, was incompetent to testify about the matter to testify about. However, because the jury's recommendation that Ritchie be sentenced to death was based on highly aggravated facts, that Ritchie raped and strangled to death a 9-year-old child, the recommendation any reasonable jury would have made, and that there's relatively limited mitigation evidence in this case, there is no reversible error. And therefore, we're going to request that this court affirm the sentence of death imposed by the trial court. There were several matters brought up this morning by defense counsel, and my intention is to limit my response to those remarks unless the court has further questions of me. With regard to the same mercy argument, the court should be aware that in Rhodes v. State, which is one of the cases cited by by counsel in this case, this court found that a same mercy argument alone was harmless error. We've contested whether or not it's the same mercy argument, whether or not it was in fact preserved, but to get down to brass tacks.
Can we talk about preservation for 1 second? What would have properly preserved the same mercy objection? I see the colloquy as being pretty clear. There's an objection, there's a motion for mistrial, and the court essentially says, all right, thank you, don't relate it to any mercy. The jury may or may not show the defendant. Okay. Is it the state's position that the court didn't rule on
That's
that
correct.
objection?
That is the state's position, but again, I think it's important, even though that's the state's position, and if it's not preserved, it's a different analysis this court would use in reviewing the remark. I think the bottom line is that even if it had been preserved, this court said that those arguments, it's a harmless error.
No, I follow. I just want to make sure I understand the state's
Yes.
position about what constitutes a ruling sufficient to preserve an objection. And it sounds like the state's position is you need an actual statement saying overruled, or is the state's position that nothing short of that will preserve the error?
I don't think that trial counsel can require the court to make a ruling. I do think that trial counsel can bring it to the court's attention that there hasn't been a ruling and request a ruling.
The judge, here's what the judge said. Says, I don't recall him saying that, but obviously relate the term mercy, related to the context of HAC. Don't relate it to any mercy the jury may or may not show the defendant, okay? That's what the judge said. I mean, I guess she could have said overrule or sustain, but that's what she said. It's even more specific. How is that not a ruling?
Because there hasn't been a formal ruling. However, as I was pointing out,
You want to hear the words, denied, granted, that kind of thing?
I think the court has to make a ruling, yes, Your Honor.
So how does the defense lawyer who is savvy about these things get a judge to do that?
If the court won't make a ruling, the lawyer can point that out to the court and request a ruling. If the court doesn't make a ruling at that point, there's nothing counsel can do. And I would say at that point, they've preserved the record by bringing notice to the court and pointing out that there hasn't actually been a ruling. However, in this case, as I'm pointing out to the court, even if the court were to find that it's the same mercy argument and that it was preserved, because it's harmless error, it doesn't matter whether in that case it was preserved, because this court's previously found in Rhodes that it is harmless error.
Let's set aside this particular issue for a moment. I think the defense argument is we've got other errors that would be considered to be fundamental, right? Because they were unobjected to. So I'm trying to determine what is it that we can aggregate together for cumulative effect purposes. Can you look at those other fundamental type errors, and even though individually they may not be reversible error rising to the level of a fundamental error, can you aggregate those together in that class together? And let's just stop there for a moment. Can you do that?
The court has done that previously. I questioned.
We've got case law doing that.
I believe the court has done that. I do question whether that's reasonable or not, because for a number of reasons. All right, I don't maybe numbers.
So, but just stop there for a moment. We do have case law saying yes, that's appropriate as a matter of law to aggregate those.
I don't know that court has come out with a statement saying, as a matter of law, that's the proper way to go
But
about
we've done
it.
it.
We've done it.
But
I said is the court
done it.
has done it.
All right, so if we can do that, then should we combine also then the prejudicial effect of one that is preserved, this particular mercy aspect, and consider that with in a cumulative error analysis, this one that is preserved, and together with all the others that are not? Is that an appropriate aggregation?
The court has looked at both objected to and objected to comments and taken a look at them. However, I do question the rationale of doing that for...
What standard?
I'm sorry?
And then you use the fundamental error
The fundamental
standard
error
for
standard, that's correct.
the objected and non-objected.
For a couple of reasons. One is with preserved errors, there's a different standard than there is with unpreserved errors. And with preserved errors, the burden shifts from one side to the other, as opposed to unpreserved errors. But what the court said is you take a look at the totality of the evidence introduced. And in this case, what we have is a case with highly, highly aggravated facts and really relatively little, if not a paucity, of mitigation. What we have is an individual who raped and strangled to death a 9-year-old child. And there was graphic testimony from the medical examiner about the strangulation and the results. We're talking about...
Well, counsel, is the argument here that you're making really that because this is such an aggravated bad case, which cries out, it's a terrible case, that the prosecutor can basically say anything? They can transgress all sorts of rules, whether it's objected to or not. They can make comments like this immigration comment, which what that has to do with anything that is relevant in this case. It's hard for me to imagine. I mean, I can't see it. Come up with statements like that, and that's really all okay because it's such a terrible case?
I don't think we can say that a prosecutor can say anything in a case. I mean, at some point, we're going to get to a point where, regardless of the aggravation, there could be the type of prejudice where we would say that a jury wouldn't have found for the death penalty, wouldn't have recommended the death penalty but for the statements. But that's not this case. I mean, the facts in this case are just so highly aggravated.
I mean, going back to the same mercy, and it is questionable to me whether it is preserved because there wasn't a ruling secured. But assuming that it's preserved error, I'm struggling to see how I can determine beyond a reasonable doubt that an argument that we said is strictly prohibited, it's one of the worst arguments that you can make, that the prosecutor can do that. There can be an objection. It can be wrongfully overruled, and then we just say, well, it's so bad that there's no way that it even contributed to the outcome. I mean, if you take mercy completely off the table with that argument in the jury's mind, how can I say that didn't contribute to the verdict? Beyond a reasonable doubt that didn't contribute. You can make pretty much even the worst argument possible and still.
Courts have to make those type of decisions all the time. This court has had to make that decision on previous cases a large number of times. And as I said, it did in Rhodes. It would require a reversal of Rhodes, as I read Rhodes, for this court to determine that it should, at this point, not be harmless error. But yeah, the court often, I should say, finds itself in a position where it has to do that subsequent to the statements that are made. In this case, which you have to take a look at the totality of the evidence that was introduced in the case.
But it seems like the stronger the state's case, the more prosecutors feel they can say. If I had a nickel each time we had this conversation, at least I had this conversation here on court with attorney generals about that situation, I'd be a rich guy right now. The immigration one, think about it. That's why I asked the question. This trial took place in 2019. The whole political climate regarding immigration at that point in time was very hot in this country. And to raise that issue that had nothing to do with anything in this case, obviously was for obvious reasons. And we can say, okay, the evidence is strong, even though he said that there's no way a jury would have found him not guilty. You can speculate about that. Well, like she said earlier, before unanimity in jury recommendations were required, we found we had jury trials as heinous, atrocious, if not more than this one, if that's possible, where jurors came back with 10-2, 8-4, things like that. So some jurors apparently, when it comes to the penalty side of it, they are very careful about this. So that's my concern. And to just say, it's harmless error, we could say that in every case, just about. So why have these rules?
And I understand your concern, Your Honor. It's obviously a question that this court has wrestled with numerous times in various cases, as you've mentioned. But if we're going to take a look at the various comments, and I'm taking it that you're talking about different comments because you mentioned the exercise of the constitutional rights as opposed to the same mercy. As long as the determination, the standard of review that the court is using is fundamental error, that's what we have, the analysis that we have to use. And in those cases where we have such highly aggravated facts, there's going to be that chance that, yes, I mean, in any case, prosecutor can make statements that may not be appropriate if, in fact, that's the statement that's not. However, this court has indicated in the past that in cases where there's substantially egregious comments made by the assistant state attorney during the case, and I don't think that this is one of those cases, it's actually stated that it would indicate that the bar may even have, should be contacted and looked into that. But what the court should not do is reverse the case, or excuse me, reverse the sentence and remand it simply to send a message to prosecutors unless there is a fundamental error in the case. And that's not the case here.
So can we get your position, though? So, I mean, obviously part of what we have to do is sort of list out what the arguable, we have to decide what were the errors and then decide whether once you've added all those up, whatever that number may be, kind of, was it so bad that essentially the defendant didn't have due process, which I think is what the fundamental error test sort of boils down to. So what's your position on, again, without getting into sort of the consequences, but as far as whether it was error at all? I mean, it seems like on the table we have the same mercy issue, the immigration issue, and golden rule. So which of those three should we even consider to have been errors?
Frankly, I question whether any of those three are errors. And
So start with the mercy thing. Why, in context, I think there's a shared understanding that even the other side acknowledged that if you limit it to the pitilessness of the crime, that it's okay to talk about mercy, but it's not okay to say don't extend mercy to the defendant because he didn't extend mercy to the victim.
Yeah, again, and I think you've just touched on that, is the fact that the prosecutor was making an argument about HAC at the time. And the fact that this defendant showed no mercy to the victim when he strangled her to death. And that's how it came up.
Okay,
Now,
but he prefaced it by saying something like, when you start thinking about mercy, consider the mercilessness of the crime, right?
And then I believe he went on to start saying, and in HAC, and that's when the objection actually occurred.
Okay. All right, how about the immigration thing? It seems like the immigration thing was, at best, kind of a non sequitur, right? I mean, can you give us an argument as to how it was, putting aside whether it was some, horrific thing to have said, that's kind of a separate question, but even in terms of understanding what this had to do with anything, could you just kind of give us an argument for why it's affirmatively okay for him to have said what he said?
Sure, but let me preface my response by pointing out that there was no objection, and that's why we're in a fundamental error analysis on that particular point. However, the defendant had brought up as a mitigating circumstance in this case the fact that he was born in a poverty-stricken neighborhood in Jamaica and Kingston. There was horrible crime, it was a crime-infested area, and that he himself was subjected by his father to punishment that was severe. The state was trying to point out, the state's allowed to argue the weight that should be given any particular mitigating circumstance. I believe that's what the state was trying to do in this situation, was point out, this is something, that happened approximately a decade ago, and he's been able to change his life. He's put that behind him, and that's something this court has recognized before in indicating whether or not that's an appropriate argument. And in this case, we have someone who's moved to the United States. In his interview with the detectives, he discussed how he was working as a cell tower operator. He was making what he considered to be very good money. In fact, he made a remark, I believe, said he couldn't believe how much they paid him to do this. And I think that's the point the prosecutor is trying to make at this point, is, that happened 10 years ago, when he was in Jamaica. He's now in the United States. Things are very different here. And he's had the advantage, for instance, of having competent counsel appointed. There shouldn't be anything wrong with an assistant state attorney pointing out, or anyone stating in closing, what's great about this country. The counsel makes it out as if he's preying on the fact that he is an immigrant from a foreign country to the United States. I don't think that was the assistant state attorney's argument at all.
Well, I guess I understand how one part of the argument is that was then, this is now. But what do his, trial rights and his, the benefits of being in the United States have to do with his personal evolution? Because I think if you're going to defend this comment as not erroneous, I need to understand how all this is responsive to the argument. And it doesn't seem like all of it is. It seems like maybe some of it is. You want to say, okay, in your past things were tough, but now you're gainfully employed. Now, you've been able to metabolize the harm you suffered as a young person. Okay, I got you on that. But what's that got to do with being an immigrant? Why does he have to reference Jamaica,
Well, he referenced Jamaica because that's what the mitigating circumstances or the evidence that was introduced for mitigation discussed. There was a whole video introduced in this case of statements taken by people currently living in Jamaica who knew Mr. Ritchie at the time. And so clearly, if we're going to talk about his past and whether he has moved on from his past, well, what is his past? His past is Jamaica. It's not as if the state introduced Jamaica into evidence in this case. The defendant did. The
Golden rule, I think.
Thank you. The golden rule violation. The assistant state attorney clearly came up to the line, I would say. But the point that the assistant state attorney was trying to make, again, I believe, at that point, is talking about give me just a second, please. Okay. He was talking about HAC at the time, and he was trying to explain to the jury they have to consider whether this was a heinous, atrocious, and cruel crime. And he was discussing what the victim went through. And when I say that the assistant state attorney walked up to the line, I'm not saying that he intentionally did that. He was trying to explain to the jury that they have to consider the fact that this girl went through what is a horrible death, that there was a period of consciousness where she knew what was going on. Not only was she being strangled to death, that she was being raped by this person as well. She was 9 years old, and trying to convey to the jury the HAC elements or the argument on HAC. And that's why I say I think that if you take the argument in context, you can see that that was the intention of the assistant state attorney. It wasn't to try to play on necessarily the emotions of the jury, which is what the golden rule violation is. He never actually specified that the jury put themselves in the shoes of the victim, and that's, I think, where technically the golden rule violation requires that. So I don't think that it may not even be a golden rule violation, frankly, but certainly in the context in which he was arguing, it explains why the assistant state attorney was making that argument. We need to bear in mind, it's not as if assistant state attorneys, when they're making their closing arguments, have a script that they're reading off of, or a choreographed or anything along those lines. A lot of these remarks are off the top of their head. And what he was trying to explain the HAC, he was making the HAC argument, and he was talking about what this victim went through, and that's how we got into that situation. I think the other issue was the victim impact testimony from the mother in this case. Now, we're not arguing that statement by the mother is a proper argument, as a proper statement. I don't think that anyone would contest that it's not a violation of pain. It clearly is. What's important to bear in mind is that in this particular case, there was no objection to that. And so the proper analysis of that argument or that statement whether or not it's fundamental or fundamental error. And that's again where we get into taking a look at the facts of the case, both the aggravation and the mitigation. And clearly, and I'm sorry, I don't recall which justice mentioned it, but this is just the type of case where we would anticipate a reasonable jury is going to come back with a recommendation of death given the severity of the aggravating circumstances. We're not just talking about strangulation, manual strangulation of a person, and I clearly don't want to make it, when I say just, make it sound as if that's not a serious matter. Obviously it is, regardless of who it is. It's a painful and torturous death. That's what the testimony of the medical examiner was about. We're talking about a 9-year-old child on top of that. The jury had already, in their initial conviction of the defendant, made a determination that he raped this child. There was a capital sexual battery conviction. And the court needs to weigh that against what little mitigation there is in this case. And the court has said in the past, I believe it's in Alston v. State, that one of the things this court focuses on is the order, the sentencing order of the judge, and where we have the judge saying that she gives great weight to the 3 aggravating circumstances, and I think it's little and medium weight, moderate weight. She gives moderate weight to the mitigator, that there was no significant history of prior criminal activity, moderate weight to the fact that he suffered mental and physical abuse by his father, and the defendant was often absent because of 4 different families, and little weight to the fact that he was raised in poverty-stricken and violent neighborhood in Kingston, Jamaica, little weight to the fact that he was the oldest of 18 siblings and helped raise them, little weight to the fact that he was gainfully employed, and little weight to the fact that he was kind and generous to others. So in determining whether or not there's fundamental error, we compare that mitigation with the aggravation. And the sentencing court did what I think most reasonable courts would do, or not most, what any reasonable court would do, just as this jury did what any reasonable jury would do, and that is return a verdict recommending a death sentence based on these aggravating circumstances and those mitigating circumstances.
Counsel, before you end, I'd like to go back a little bit to that golden rule violation argument. I think you said it went up to the line, but didn't cross it. So I just want to make sure I understand where you think it would cross. Because what he said was, can you imagine the dread of knowing that your life is ending and you're feeling pain all over your body? And then he describes that in fairly graphic detail. And then he said, and that pain would have been greater for a little girl. So I'm trying to figure out how that's not a golden rule violation. Because, I mean, I know you said, they have to say, put yourself in the shoes. I don't see how he could have said that any clearer.
And I recognize that it's at the very best a close call. But again, there's no objection. And the question is whether or not there was a fundamental error in the case. And given the facts of this case, including the fact that the jury had already found 2 of the aggravating factors existed in their initial conviction, therefore finding the defendant was eligible for a death penalty prior to the penalty phase itself, that's not a fundamental error. And that's really the bottom line. And that's truly the bottom line of this entire case. If you take a look at the cases, was there fundamental error in this case? And when you take a look, and I feel like I'm kicking a dead horse here, but
Well, let me just ask one more question. That's about all we have time for. But so the back to the same mercy problem, the Merck versus State of Florida problem. The only contemporaneous objection was in response to this. The prosecutor says, I want you to think about this again when you're back there deliberating, when you're considering whether you should give him life and whether you should personally extend mercy to this defendant. Did he extend mercy to this little girl? Now, would you concede that that is an improper prosecutorial argument?
I think if we take it in the context of in which the argument was being made, which is whether or not...
Doesn't that do exactly what the case law says you can't do? I mean, the context is when you're personally deliberating and when you're personally deciding whether to recommend life or death, think about this, did he extend mercy to her? That's the context of that statement.
Right, but you say that's the context of the statement, but that's not the entire statement before the objection. There's not much more. But what he then says is because in heinous, atrocious, and cruel instruction, and that's when the objection comes. And that's why I keep hearkening back to the fact that the assistant state attorney in this case was making a heinous, atrocious, and cruel argument. And that's where the language slipped in.
Counsel, you're over time.
I was
so
just-
if you could sum it up in about 30 seconds.
I will. Thank you very much, Mr. Chief Justice. For the foregoing reasons, we request that this court affirm the sentence of death that was imposed by the trial court. Thank you very much.
You, rebuttal.
Counsel, could you articulate for us, I want to make sure that we understand your position on the fundamental error
Yes.
kind of test, because it seems, I'm trying to the extent that it ultimately goes to due process, it seems
Yes.
like the due process right that's at stake here is the right to have the jury make a decision on their recommendation based on reason and their assessment of these arguments, some of which are factual and some of which are kind of moral / subjective sort of judgment type arguments.
Yes.
And we have all these kind of guardrails in our case law that seem to be all directed to the end of keeping this a rational process. So that's why you don't do the golden rule. That's why you don't do the mercy thing. It's not because there's something sort of inherently flagrantly problematic about an argument like that. It's that it can encourage the jury to maybe cross the line into not having this be a rational sort of decision that they're making and having it be more based on sort of passion or emotion. And so is it appropriate for us to read this entire argument and kind of ask ourselves, keeping in mind the guardrails that we've put up and whether the prosecutor stepped over the line in, all of these cases or some of them, but do we ultimately need to read the entire closing argument and ask ourselves, were these things in their cumulative effect sort of so far over the line that we don't have confidence that this jury made a rational, kind of reason-based as opposed to passion-based decision in this case? Because it seems like if that's the test, I would have a hard time saying that there was fundamental error. If it's more a matter of just sort of mechanically kind of adding up, how many mistakes did the prosecutor make, then maybe you have a stronger case. Could you kind of address that?
Sure. If the court is applying fundamental error, which we're arguing that you should not, but if you are, I think there is a undeniable connection between excess emotion, right? Because you cannot completely divorce these proceedings. I would not wish being a capital juror on my worst enemy. It seems wrenching. You cannot completely divorce these proceedings from empathy, rage, and so prosecutors have to ask themselves, am I going to cap it at that? Am I going to try to keep it under control? Or am I going to essentially pour gasoline on something that is already on fire? And when they choose to pour gasoline, what they are doing is they are impairing the integrity of our state's capital sentencing system, a system that this court should ensure by all its might is as sound as possible. And I think there's a connection between the excess and fundamental error, right? Because when you err fundamentally, what you do is you err so extensively that you impair the jury's ability to, as calmly, as dispassionately as possible, arrive at a fair verdict. And these arguments are banned because they work, because they cause jurors in the capital context to impose a higher sentence than they otherwise would, because they whip people up. That's why you're not supposed to say them. So the question, I think, if you're applying fundamental error analysis, is how much do we tolerate? And this is beyond.
Well, but I think that's why, though, I mean, if you read the whole argument in context, you know, obviously I think it sounds like from the state's own argument, it sounds like in hindsight there are some comments that the state would acknowledge maybe shouldn't have been made. But if I read the entire argument, I do see, you know, a lot of sort of reasoned application of the HAC, the other aggravators, putting all of it in context, responding to the mitigation, which is, you know, obviously a difficult thing because it's not just a sort of who's proving a fact. It's trying to make inherently kind of moral arguments to the jury about, you know, what weight do you give the bad, you know, versus the good. And when I read the whole thing in context, it doesn't read as an argument that was trying to, you know, to where someone, the hearer would have been so overwhelmed by emotion that they couldn't kind of rationally apply the standards, which at the end of the day, I mean, that's what this whole process is about, right? Is giving each side a fair chance to kind of make their arguments about the legal standards that apply, the facts, and have the jury kind of make this moral decision about what their recommendation is going to be. And it seems like in context, there was an opportunity for them to deliberate that way. Do you disagree with that?
I absolutely do. This idea of any reasonable juror would vote for death in this case is misguided.
Well, and that's just to be clear, that's not what I'm saying. What I'm saying is I'm not saying what their answer was. I'm saying the environment, were they able, after this argument, to make a reasoned sort of assessment of the case that had been put in front of them? Because that's ultimately the test, right? I mean, it's to protect against the jury basing their decision on passion. I mean, isn't that all these rules that we have, they're all directed toward preserving that interest of
yes,
of the
and I think
defendant.
same mercy, an attack on the idea of unconditional mercy inflames your passions. I think an attack on your jury trial rights, the very proceeding that the jurors are sitting to, inflames your passions. I think, especially after the last election, these anti-immigrant sentence inflames your passion. And I think the golden rules violations also inflame passion. That's the whole point of a golden rule violation, is to inflame your passion. So I think if we're in fundamental error world, again, which we should not be, but if we are, I think all of those things do exactly what you frankly seem to disagree with me about. I think that they're designed first. I mean, that's the key here. I heard my opponent say that some of these things were just off the top of his head. There is no way that is true. Mr. Harmon is a veteran prosecutor, has been prosecuting homicides for 20 years. He wrote out this argument. He gave it to colleagues, I guarantee you, and tested it. This was deliberate. And another thing that his wisdom gives him from doing this for so long is that even if I've got aggravators on lock, I can still lose. Especially in a case like this that is not, like my opponent said, one of the least mitigated. You have two of the most, and it doesn't matter what the trial judge's order said, it matters what the jury thought about the mitigation. You have two of the most compelling categories of mitigation that exist: traumatic childhood physical abuse and mental mitigation.
I'm sorry. Could I ask you about this preservation issue with the mercy thing? Because one of the consequences of not getting a more clear ruling from the court is that there was no opportunity to sort of discuss whether there could be some kind of curative instruction on the spot. Because I mean, on your theory, am I right to understand you as saying that as soon as that sentence or the two sentences left the prosecutor's mouth, that
The error
essentially
was complete.
that there had to be basically we have to start the whole penalty, what should the judge have done?
The mistrial should have been granted.
And which means you would do what?
That the
For the-
penalty, I assume that
so
the
we-
penalty phase would start over.
Right, we just start, so because there wasn't there was no curative instruction that could have been given, the court couldn't have said, listen, I know this came up in the context of it may have been an improper mercy thing, it may have been a proper HAC thing, I want you, the jury, to understand this is what you can consider it for, but you cannot consider it for something else. You're saying that would not have been acceptable, that couldn't have fixed the problem.
There's a couple schools of thought on curatives and whether they help at all or whether they hurt. But I think what's important to remember in this case is the trial judge clearly didn't think an error occurred. So at that point, and as a former trial attorney, I've been in front of some judges where if they make their opinion clear and I ask for a curative, I'm going to get looked at like I've got three heads.
Well, but the problem is here, it seems like to the extent that the court thought there wasn't an error, it wasn't because the court disagreed about whether it would have been okay
That's
to
right.
make the argument. It was whether, in fact, the lawyer had actually said,
That's
in
true.
terms of how you heard it. So there was a common understanding that this type of argument was off base. And so if defense counsel had said, well, can we just make sure the jury understands X, Y, and Z, it seems like the judge would have been receptive to that because the judge agreed that the comment would have been inappropriate for that purpose rather than for the HAC purpose. And none of that was able to happen because of, and I'm not saying this to fault the defense lawyer,
Sure.
but because of the ambiguity about the ruling and the failure to kind of follow up, there wasn't an opportunity for that to happen.
That's correct, but I mean, it's our position that this closing argument went on to be, maybe if you take it out of that single sidebar context, went on to be so devastatingly bad that it's reversible anyway.
And let me follow up with that. So
Yes.
if you read, again, at the same point, the same mercy argument,
Okay.
the objection,
Right.
you're correct. It really wasn't a general objection. If it had been, then the judge, I think, the judge would have said, sustained, you know what you can't do, don't do that again, and we would have moved on, right? So, and essentially that's what the judge did. The judge said, well, I don't think he said that, but we know he can't say that, so don't do that again.
Right.
So if we view it as a general objection, then it was handled properly with an instruction, this is not the kind of argument you can make. So
Do you mean,
And
by
then-
general, what do you mean?
just objection, this is an improper argument. Then the judge would say, sustained, you're right, it was improper, don't do that again. That would have been it. But it was a motion for mistrial. And it's a tough road to think that simple comment in the context of the HAC argument would vitiate the fairness of the entire proceeding. So when you look at the mistrial standard, I don't even think you argue that the judge, you don't make that separate argument, right? That the judge should have granted the mistrial.
Well, I think the mistrial in this particular sidebar exchange is sort of a red herring because the judge
But that's
is
the
clearly-
objection that was actually made. It was
I
a motion
understand,
for mistrial.
But no, I'm talking about the failure to obtain a ruling for that. I think is a red herring because once the judge makes a clear ruling on an objection, once you lose an objection, you don't have an obligation to make or obtain a ruling on a motion for mistrial.
Okay.
Counsel, you're now in overtime, but I'll give you another minute to sum up.
The state has simply not met its burden to prove beyond a reasonable doubt that a single juror was not swayed by any of these putrid arguments. The vast amount of improprieties in this case have been described in many cases by many courts in a lot of ways. There is but one word that adequately describes them in this case: reversal. Thank you.
Thank you. We thank you both for your arguments and